It's working. Hi guys, Nika here with your second daily neuro nugget of the day. I am actually very exhausted, not caffeinated, have not slept. This is a This is one of the most important memorandum final decisions, and it involves the order on the death penalty motion. And we knew, most of us, very early on, that Judge Hippler has no chill. This is good and bad in my opinion. The good thing is that you don't have the BS going back and forth with Bill and the defense team, and this judge has control of his courtroom, right? We don't necessarily have to all like him, but that can be said. He has control of the courtroom, and he seems like the type of person that when he makes up his mind, he makes up his mind. Like, there's no turning back. And of course, we have this memorandum. So the entire document is 55 pages long. It's very lengthy. We're not going to go through all of it. I did skim most of it, and it's the same thing. It's basically Ann Taylor and the defense team saying that there is an infringement on Kohberger's rights when it comes to the speedy trial, because it mixes up a lot of questions regarding the death penalty. And we know that Idaho has had issues when it comes to executing people. We know that there was a case not that long ago where they had to try to get the IV in a man who was supposed to get the death penalty. They tried to poke him over 8 times, if I'm not mistaken, and they were unsuccessful. So they ended up rescheduling everything because they couldn't do their job right, basically. And Ann Taylor is saying, you know what, this is not right, this is inhumane, this is unconstitutional. And I am just scrolling. I'm just gonna go to the most important parts that you want to hear, because nobody wants to go through 55 pages of boring legal speak, right? As usual, Ann Taylor and the defense team is saying that it would be cruel and inhumane or degrading treatment or punishment if there were an excessive delay. Like the example that I just listed, they're saying, okay, if you don't have the proper tools to give this man the death penalty, then it's too much pain, it's too much suffering to have them wait in jail for God knows how long until you get, you meaning the state, until you get your things in order. So please, in the chat, let me know if somebody truly committed a crime. I'm not saying Kohberger, I'm just saying criminals in general, right? Do you think that that is unconstitutional? Do you think that that is inhumane? Being in jail, waiting to whenever, you don't know when, until the state gets whatever tools necessary to end your life. Please let me know in the chat. Is that inhumane or not? Because I feel like this is something most of us are going to disagree on. Muted. Can you guys hear me? Hi, Jennifer. Hi, Sleuthy Kitty. Hi, Queen. Hi, Dawn. Hi, Jay. Hi, John. I think you guys can hear me. I don't think it was muted. It was probably when I was typing, maybe. Do you guys think that it is ethical or unethical to have to wait? If I'm honest, if I'm completely honest with you guys, and let's say that we have a criminal and we are 110% right, which, you know, we usually don't know what we're doing. But let's say we have this man on tape and we know that he killed 4 people. In my opinion, I don't give a shit if you have to wait in jail for 10, 20, 30 years. Like, when your day comes, it will come. We don't have to tell you. We don't have to warn you. Why should we warn you? Why should we give you a specific date? We don't owe you that, right? Because you didn't give time, you didn't give a date to the victims of the people that you took out. So I don't think it's cruel and unusual punishment. I understand the argument that Ann Taylor is trying to make, though. But I just think that's a bad argument. I just think that's a bad argument. I'm sorry. Like, not only that, but Judge Hippler said, fine, if you think that this is degrading, right? And honestly, I don't think none of this applies to Kohberger, because most of us don't think that he committed the crime, right? Because we haven't really seen enough evidence. But if he really did do it, I mean, let him rot in jail until whenever, right? I think that's most people. That's what most people would say. But that's just a weak argument. I guess I finally disagree with something Ann Taylor is arguing. And again, I understand, right? She's the defense attorney. She has to kind of really pick apart the Constitution and this death penalty motion to save her client. I'm just scrolling here on page 50. 52. 52, right? And the Judge Hippler is saying, okay, the defendant's motion is not ripe, okay? Ripeness means that it's ready. It's ready for picking. And what Judge Hippler is saying is that, yeah, this motion is not ripe. It's not time for this yet. It's way too early to try to argue for the method of execution, because, again, there are no hard and fast rules to when a method of execution claim becomes ripe. So Judge Hippler is saying it's too soon for this. The motion is not ripe. We have to wait and figure this out. At this time, this is not our priority. That's what he is saying here, right? And then when we go to page 53, he also makes a very valid point. Again, I understand Ann Taylor and her team are trying to pick apart the Constitution. That's their job. They're trying to do the best they can to defend their client to their fullest capacity. But Judge Hippler is right when he says that the lethal injection and the firing squad have been found constitutional by the U.S. Supreme Court. So even if Kohberger's motions were ripe, it has been foreclosed by prior U.S. Supreme Court precedent findings, both lethal injection and the firing squad to be constitutional methods of execution. So yeah, that's not going to hold up. And Judge Hippler adds a case here, Wilkerson versus Utah, and says cruel and unusual punishments are forbidden by the Constitution. But the punishment of shooting as a mode of executing the death penalty for the crime of murder in the first degree is not included in this category. within the meaning of the Eighth Amendment. Moreover, the U.S. Supreme Court consistently cites to Wilkerson as upholding a sentence to death by firing squad imposed by a territorial court, rejecting the argument that such a sentence constituted cruel and unusual punishment. So he's basically saying, yeah, we've already done this back in this Wilkerson versus Utah case, and this is a case that has been used to uphold the firing squad and the lethal injection. So Hitler's like, nice try, Anne, but yeah, you're wrong. This is constitutional, right? And he makes a very interesting point as well, that the defendant has failed to identify an alternate method of execution, because in the last motion for this death penalty hearing, we saw Hitler telling Ann Taylor and the defense team, fine, if you are against lethal injection or firing squad, then you need to give me a backup. You, Ann Taylor, and the team need to give me a backup. How would you like to pass away, Mr. Kohberger, if you needed to, if you were to be given the death penalty? And they didn't give a backup. So a prerequisite to challenging the Eighth Amendment is that you need to be able to show an alternate execution method, right? But Ann Taylor and the defense team didn't do that. And he goes on and says that this was not done. So the Eighth Amendment does not guarantee a prisoner a painless death. So even as somebody like myself who currently still believes that Mr. Bryan Kohberger is innocent, because he should be innocent until proven guilty, I am trying to be unbiased, and I'm trying to see things from a constitutional manner, following our Eighth Amendment. And Hitler he's right. He's right. You can't just challenge the Eighth Amendment and then say, yeah, we don't want to give you backup because, it's too ripe. So Ann Taylor is arguing, it's too soon for that, Judge. It's too soon for us to give you backup. But he's saying, no, it's too soon for you to worry about the manner of the death penalty, because it's too soon for that. We don't even know if he's going to get the death penalty or not yet, right? So a lot of back and forth there. Now I'm going to go to page 54 here. Defendant acknowledges he has not identified an alternative method, but contends his claim is distinct from the method of execution claims in Bucklew, Bays, and Glossop. He argues Idaho's chosen methods are unconstitutional because they threaten Idaho citizens with a means of execution that cannot be carried out without causing undue pain. Undue pain. However, this is not a distinction that can be drawn. Undue pain is precisely the question that the foregoing method of execution cases address. To strike a method of execution as unduly painful under the Eighth Amendment, defendant must come forward with an alternative method. My phone is dying. He has not done so, thus foreclosing his claim. So basically, this was all a waste of 55 pages, guys, right? Because Ann Taylor and the team did all of this work. They tried to argue that this was unethical, that it was going to cause excess pain, blah, blah, blah. They were required to give this alternative method, which they failed to do. So now, at the very end of this 55-page document, it says, order. Based on the foregoing analysis, the defendant's death penalty motions are hereby denied. It is so ordered. Dated this 19th of November, 2024, Stephen Hitler, Admin District Judge. And there you have it, ladies and gentlemen. That means that death penalty is still on the table, as we assumed from the get-go, right? That being said, there have been other documents that have dropped as well. I am exhausted, so I am not going to go through them today. I need a nap and food. Listen to your body. A little mental health reminder, guys, if this case gets to be too much, or any crime sleuthing for you gets to be too much, if it's causing you anxiety or whatever else, you need to back away. You need to back away. For me, it doesn't cause stress, but I'm tired because I work jobs, several jobs, 2 jobs at the moment. So always listen to your body. This will always be here to wait for us. That being said, I want to come back sooner than later to cover the rest of the motions. There were 3 documents that dropped today, right? It's the amended order appointing the Special Assistant Attorneys General, the order sealing all exhibits in support of motions to suppress, and the order sealing the defendant's memorandum in support. So we're going to go through all of those eventually. And yes, I know, I don't hate me. I still have to talk about Olivia Gonçalves. I hope you guys all have a wonderful weekend. Leave a comment, leave a like, and let me know what you guys are going to do this weekend. Maybe I'll see you this weekend. So, not promising anything though. You guys take care. Bye-bye.